Thank you everyone for giving me the occasion to come here and speak to you today and share some of my experiences with mediation. I understand that it's not a good position to be in when you're the last person standing between you guys and lunch. So I'm going to make this as quick and crisp as possible. Uh, so I've been a corporate lawyer now for about 17, 18 years, and I've had the occasion to deal with several commercial disputes, joint ventures, private equity investments, etc. What I've learned, of course, is that conflict is inevitable. As a business grows, conflict is inevitable, but combat is optional. So if you have the right mindset to try and avoid combat, you will have enough occasions to feed that, in the sense that if you have the right attitude to try and ensure that litigation, arbitration, and the costs and time related to that doesn't pull down your business, we've all seen through the course of the day that mediation is an excellent tool. The few characteristics about mediation that we've all heard over the course of today, I just want to quickly sort of summarize all of that. We know that mediation is a neutral process. It is a voluntary process. Anyone can join in and stop mediation at any point in time. It's a party-centered negotiation, so it's not like two lawyers are fighting for you in court where you're like a bystander sitting in the courtroom seeing what's happening. It's an informal process. There's no strict guidelines in terms of how you have to submit documents, how you have to present your arguments, etc. It's an assisted negotiation process, so it's facilitative, it's negotiations between two parties, which is assisted by a trained mediator. And most importantly, is what most of my clients have been happy with, is that it is confidential. So all the documents that you submit, the result that happens, all the submissions that you make, all the discussions that you have are completely confidential and will not be, and there's no obligation for those to be disclosed anywhere. I think we've already, I think Mr. Kulkarni has been very kind to take us through all of the legal recognition of mediation in India, so I'm not going to spend any more time on this. So after all the sort of conversations that we've had since morning, if you still need a reason, I'm going to give you 10 reasons why mediation makes more sense than litigation. As I said, parties have control. It is more participative. It is a speedy and efficient way of resolving disputes. It is simple and flexible. It is confidential. There is communication between parties. The results are long-term. So it's not like you get an interim injunction and then wait for 10 years. It's not constricted by the four walls of what happens in the law. It can be creative. There is finality, and in some cases, of course, if it's a court-driven mediation, you can also get a refund of court fees. So this was a brief sort of introduction. I think I'm going to spend about 10, 12 minutes on some of the mediations that I have been involved in. So over the years, I've had the occasion to be involved in several mediations. What I'm going to do is take you through 3 of them. The first one was a court-directed dispute between 2 business families. The second one was an ad hoc mediation in relation to 2 parties, one foreign, one Indian, related to a trading of goods. And the third one was a institutional mediation under the auspices of the ICC between 2 joint venture partners. So the first one was, we had a situation where there were 2 business families. One was in the manufacturing of chemicals, and the other one used to supply the raw material for those chemicals. They'd been working together for many years. They were friends. Their kids got married. That's when the problem started. So the husband and the wife decided to claim alimony as part of the divorce proceedings. The husband said, I don't have any money, so I'm not going to pay you alimony. The wife then challenged a will. So the father had left a will by which all his property, so the entire business, was left to the father's wife, so his mother, and the other son. So the son who was who was implicated in the divorce proceedings had no property left under that will. So the wife obviously was upset. Their family challenged the will, so there was a testamentary suit challenging the will. There were criminal proceedings. There were criminal proceedings filed by the husband's family as well on the other family for harassment. Needless to say, all their business relationships for the last 15 years, which was cultivated, completely came to a standstill. They couldn't go further, and parties realized that we need to do something about this. The court recognized this, and in the High Court, as part of the testamentary petition, they decided that maybe mediation under Section 89 was an appropriate solution to do in this case. What they therefore did was, a very senior gentleman, a senior counsel designated by the High Court, was nominated to be the mediator. The senior counsel, unfortunately, wasn't trained in mediation. So he called for the parties to meet together. He called their lawyers as well. Both of them presented their case. He heard both of them as in there were arguments. Over 2 or 3 sessions, he then, on his own, because of course of his legal acumen and his impulse to form a judgment on any issue that comes before him, he formed his opinion on each of the issues, basis the law, and decided that this is the way in which the parties should be settling. Now, the moment there was no consultative process with the parties, this gentleman, of course, very renowned lawyer, decided to form his own judgment on how this dispute should be settled and gave his views. Needless to say, of course, it failed. The parties were now more angrier with each other. They believed that now negotiation is there's no case for negotiation. The matter went back to court. It's been about 10 years and they're still litigating. All the properties of the business family which were part of the will, there's an injunction on. So they can't grow their business, they can't sell their properties, the wife cannot remarry. It's a huge issue and it's going on for the last 10 years. So as I'm saying, this is one case where I've seen, unfortunately, where the mediation has failed for reasons that are just sort of eliminated. Moving on, there was another client of ours. He was a Korean company. This was a large Korean company which was into buying and selling of grain and fertilizers. They had received an order from a European company to supply a shipload of grains. They didn't have the capacity to supply it themselves, so they came to a group in Gujarat who also trades in grains and said, please help me supply this. So 4 entities from that group were contracted to supply the required quantity of grains. The group in Gujarat failed to perform. After they failed to perform, the Korean company had to go and buy these grains at a very high price from somewhere. There was a delay in shipment and there was liquidated damages. So they decided that all the losses that we've incurred, I'm going to claim it from this group in Gujarat. They have a grain and feed trade association called the GAFTA. The GAFTA has the auspices for arbitration, which is recognized by the International Chamber of Commerce. They filed for arbitration. The GAFTA held that the entire amount of loss has to be paid by the 4 entities to the Korean company. Obviously, they didn't pay. The matter went into appeal. In appeal also, the Gujarat entities lost. The matter was then, so there was an award which was to be enforced in India. As you know, enforcement in India of an award is a huge task altogether. So even after you win an arbitration, enforcement can take a few years. As part of this enforcement, the Gujarat entities filed an appeal. They went up to the Supreme Court. For about 3-4 years, the matter was languishing. We then, as advisors for the Korean company, were approached by the group and said that they'll probably want to evaluate settlement. We proposed this to our client, said that this is probably the best way to go because otherwise you're going to waste more and more years in court. They went ahead and decided that they will have an ad hoc mediation, which is going to be non-binding. We explained to them that don't worry about that. They approached and engaged a partner in Ahmedabad of a Big 4 accounting firm. He was well respected. He was not a lawyer, but he had a good, astute commercial sense. So he did not understand commercial processes and arguments and who's going to win and lose. But over a period of about 2 months, he had separate meetings with the clients, separate meeting with the parties, in a very disarming and appropriate manner, without getting them face to face because they didn't like each other anymore. He was able to convince them that the only way to get this through is if the Korean party agrees to a smaller number, places a subsequent order on the Gujarat entity, which was unheard of after they'd already started fighting, and also provide them a little time to make this make the payment. The Korean entity understood that this was probably the only way to get it done. They went ahead, accepted that. So the only time the Korean entity and the Gujarat entities actually met face to face was to sign the final settlement agreement. Once that was done, all the payments have happened. There's one payment left, which is happening next month. The proceedings will then be withdrawn. The amounts have all been paid. The parties have now also started trading with each other as they were earlier. So business and relationship has actually had gotten worse, and now it's come back to a situation where they have faith in each other that if there is a problem, they will be able to sit across the table and resolve it. The third one is, there was a joint venture company who we'd worked for several years, 50% owned by an Indian family, 50% held by a French company. This was in the auto ancillary sector. So they used to supply parts. They started off with supplying parts to, Peugeot 309, which happened about 25 years ago. So for 25 years, this company was in existence. The parties had very good, cordial relationship with each other. After some time, in the 20th, 23rd year, there was a dispute between them on whether certain payouts should be recognized as business expenses or not. Now, ordinarily, one would expect that things will get sorted out, but they did. They spoke to each other, it didn't work, things got a little more heated, the promoters had an argument over the phone, there were lawyers involved, there were notices sent. In the end, after about 2 years of some acrimonious notices, etc., they decided that the best way to go is court. So the French company filed before the National Company Law Tribunal for what is known as oppression and mismanagement. Excuse me. The Indian company filed for a civil suit in the High Court saying that the directors of the company are not fulfilling their fiduciary duty and therefore a penal consequence should be imposed on them. There was also an arbitration filed before the International Chamber of Commerce in Paris, where the seat of arbitration was to be in Paris, for a breach of the joint venture agreement. So while the Indian party accepted the arbitration notice and said, okay, we'll go to arbitration, they also sent them a notice calling upon them to evaluate mediation under the auspices of the International Chamber of Commerce. Thankfully, the French entity was okay with it. They didn't want to talk to each other, so the lawyers got together and we appointed this gentleman called Mr. Bill Marsh, who's also on the panel of the Bombay Chamber of Commerce. He's Queen's Counsel in the UK, so an excellent lawyer, has been in the profession for over 35 years, but doesn't practice law anymore, does only mediation, is trained to do only this. So Mr. Bill Marsh first understood the problem from the lawyers so that he heard a version that is not colored with emotion and sentiments. After understanding all the facts, he read all the documents, so he was completely then thorough with the facts. Then, after a series of meetings which went on for about 3 or 4 months, he was able to come to the conclusion that it is not possible to get them back to continue their joint venture. So even if they continue their joint venture, there is almost, in every possibility that they're going to find a way to get back into dispute. He therefore realized that it's irreparably damaged, and the only way to solve this is probably a split. He convinced the French company that it's not going to be possible for you to continue with this company in India from France. And he convinced the Indian gentleman that you should make an appropriate fair offer. Though it may be difficult to come up with the funds to buy the company, it is worth the stretch. And he convinced the French one to give them more time to pay. Once all of that was settled, parties entered into a share purchase, first a settlement agreement, then a share purchase agreement. As of last year, all payments have been made. The Indian company has bought out the French guys. Relationships are cordial. When they come to India, they go out for dinners. In fact, last summer, the son of the promoter of the French company interned with the Indian company. They still collaborate on certain projects. So while they're not in joint venture together, they've found a way to put their disputes aside, find a workable solution, ensure that their disputes don't result in the actual company that they've built together being destroyed. And they were able to come out, get over their ego, and form a sensible way to move forward. So I think, these are the 3 things that I've had the occasion to, share with you, which all 3 sort of different parameters, some ad hoc, one sort of a family dispute, which also happens amongst a lot of business families in India, and the third one was an institutional arbitration, the institutional mediation, which preceded arbitration. I think the main learnings that I want to share with you that I've had over these, the course of several mediations that I've been part of, so the firstly is that it's important to have the right mindset, as someone, I think, Ms. Juhi said some time back, is when you're in a dispute with someone, there's a factor that can make a difference between your relationship being damaged and your relationship being deepened. The only thing that matters is your attitude. You cannot shake hands with a clenched fist. So long as you have the right attitude, you will be able to get past most of your conflicts. It's important to choose and spend the time to choose the right mediator. He has to be trained. He has to have a mindset which is impartial. He should not be quick to make judgments, and both parties should implicitly trust him, where he's not wanting to impose his opinions on the parties to try and come to a solution. And third, I think the last one is that in mediation there is no requirement to win. The requirement is to try and find a solution. And so whether each one gets a good deal or not is in the end, in my view, a state of mind. Mediation may not always get you what you want, but in most cases it'll get you what you need. So I think that's where I want to stop. If there's any questions, I'm more than happy to take them now or subsequently. Sure.
Thanks a lot.